Hello, my name is Amelia Fletcher. I'm Professor of Competition Policy at the University of East Anglia. I'm also a member of the board of the Competition and Markets Authority, and I was a member of the Digital Competition Expert Panel in the UK, sometimes known as the Furman Review Panel. I should emphasise that I'm speaking in my academic capacity, not for the CMA. I would like to thank the OECD for inviting me to speak and for giving me a number of questions to answer. The first of which is, what are the key challenges that arise in examining acquisitions of startups? And I would like to highlight one particular challenge, which is trying to assess the counterfactual. So what would have happened in the absence of the merger? And that's really important because clearly if a startup was not going to be a success, then there's no problem from the merger. If a startup was going to grow and be successful and be a real competitive constraint to the acquirer, then there is a potential problem from the merger. So this is, however, an inherently forward-looking exercise. Now, merger assessment is always forward-looking, but normally the go-to counterfactual in a merger is the status quo. We assume that tomorrow will look more or less like today, absent the merger. But in dynamic markets, in innovative markets, very often that won't be the case because small players may grow very, very quickly, or they may grow not at all. And it's very hard to assess which is the case. But where they do grow, you may see S-shaped curves. So what you see is firms growing very slowly at first, a few early adopters try them out to see what they think. And then if the product's going to be successful, if those adopters like it, it can suddenly go mainstream and you see a massive acceleration of take-up. And then finally you'll see a deceleration of take-up as the last few laggards get on board. And that S-shaped curve is pretty standardly seen in a number of innovative markets. You also tend to see an S-shaped curve like that in markets characterised by network effects, where everyone wants to be on the same platform as everybody else. So in the early days, people kind of test the waters, a few people will dip their toe in, and it isn't until everyone kind of sees where the direction of travel is headed, where everybody else is going, that lots of people will suddenly shift. And then you get the last few laggards again. So again, you tend to see these S-shaped curves in innovative markets, in dynamic markets, and markets with network externalities. And digital platform markets exhibit all of these characteristics. And that's what makes assessing the acquisition of startups in these sorts of markets particularly complex. I would just like to emphasise, though, that sometimes commentators feel there's only going to be a concern if the startup's going to be a huge competitor to the acquirer. But actually, if you have a market where there's already limited competition, as is true in a number of digital platform markets, then actually even a relatively small competitor could provide a really valuable competitive constraint, and taking that away could still be a substantial lessening of competition. Now, outside of digital tech and into DNA sequencing, this was one of the things that I thought was interesting about the recent Illumina-PacBio merger, which has now been abandoned. But as I understand it, Illumina had around 80% market share worldwide. PacBio only had about 10%. And was one of a few competitors, although the biggest of those few competitors. Now, we usually wouldn't worry about an increment of 10%, but we do worry if the increment is from 80 to 90% of the market. So the amount of increment will have a differing effect depending on the overall competition in the market. PacBio may have also been going to grow, but it didn't matter, in my view, whether PacBio was ever going to grow as big as Illumina. That merger was still anti-competitive. So the second question I've been asked is, how should these mergers be assessed differently by agencies? I think the inherently forward-looking nature of these mergers the focus on innovation and market take-up and market developments rather than just pricing means that the typical agency approach of looking at historic pricing and sales behaviour is not going to be of a lot of use. All the sophisticated econometric analysis in the world will only tell you about the future if the past is a reliable guide to the future, which it's not. So instead, in terms of the present day, I think rather than thinking about pricing strategies or such like, you need to think about whether the firms that involved are strategic competitors. So, thinking about what do their strategies look like. In terms of thinking through the future market developments, agencies are not experts. So they have to learn from those people that do know, and those people are going to be the parties, but also their competitors, also their customers. So how do those various parties expect the market to develop? What do they think would happen with and without the merger? I think internal documents can be hugely valuable for assessing that, and that includes not only the internal documents of the merging parties, but potentially also those of their customers and those of their competitors. All of that can be really important. Now, thinking about the current and the future doesn't mean the past is entirely irrelevant, and I would emphasise that the past behaviour of the acquirer can be informative. Does it have a history, this acquirer, of gobbling up all of the small rivals in a particular market segment? If so, I think that history, that this is relevant to assessing the current acquisition. Is it part of an overall strategy? I think it's also important to highlight that we can't just think about horizontal concerns in these sorts of mergers, but also conglomerate concerns can be important. I realise there is a separate OECD panel in June on these concerns. But in fact, I think these are particularly likely given the ecosystem nature of large digital platform markets. So, for example, you might see a platform buying a particular firm with a particular technology that would usefully feed in not only to its own service but to the service of competing platforms. By buying it, that platform can potentially restrict its major competitors from accessing that technology and gain a competitive advantage, and clearly that could harm competition. And I believe that was the issue in Google ITA and led to a behavioural access remedy. The third question I was asked is valuation analysis useful as a tool in these mergers? Yes. I think it can be hugely useful, not necessarily just in terms of being decisive in its own right, which it might not be, but in terms of raising really important questions. So if the acquirer is claiming a business is insignificant, if they're just buying the people, then why are they paying billions of dollars? ? And I think all of that is really important for allowing the agency to develop a clear and consistent understanding of the likely impact of the merger. So I also think the internal documentation around the valuation exercise can be really important. What are the underlying assumptions being made in this in that documentation? The next question I was asked is, are dynamic efficiencies relevant within a merger setting? And yes, they are. And it's worth highlighting that there are direct and indirect efficiencies. So in terms of direct efficiencies, fairly obviously, there are synergies in terms of, for example, bringing technologies together to make better technologies, bringing research capabilities together to generate better R&D pipelines. There can be marketization benefits in terms of a large platform bringing its financial reserves, its established user base to a new product, a new firm, and thereby enabling that firm to take its idea, its product to the mass market much more easily and effectively than it otherwise would be able to. So those are direct efficiencies. In terms of indirect efficiencies, I think it really is important to bear in mind that the ability to sell out to a large platform may be one of the drivers behind a firm starting up in the first place, and also one of the reasons why it's able to access venture capital. So there's a very real risk that if we make these sorts of acquisitions an awful lot harder, that could kill the golden goose, as it were, in terms of disincentivizing new startups in the first place. That said, it's a really delicate balance. If firms know that the only way to grow is by selling out to a major platform, then that could in turn hamper certain sorts of innovation and investment. And doing the Furman review, we were told that it was a lot easier to get startup finance than to get scale up finance to really start to take on the big platforms head to head. The next question we were asked, or I was asked, was why did the Furman report decide not to recommend reversing the burden of proof for merger assessment? Now, it's interesting, John Vickers recently gave a speech where he highlighted that when the UK merger regime was revisited for 2002, actually a reversed burden of proof was discussed for all mergers. And this was based on a substantial body of economic evidence that, on average, mergers do more harm than good. Now, in that case, the decision was taken that reversing the burden of proof would be unduly limiting. And I think that was the right call. I think that it would have overly inhibited a number of efficient and positive mergers. Given the efficiencies that we were just discussing, and also the complexities involved in assessing them, likewise, the Furman panel felt that reversing the burden of proof would be a step too far for digital mergers. It would dampen down those efficiencies too much. That said, I think considering the overall evidence on the impact of mergers, and the huge amounts of uncertainty that we're dealing with in these kinds of mergers where we're trying to assess a counterfactual involving a startup firm, so much uncertainty can mean that the current merger test is an awfully long way from the reversed burden approach. So it's not like we have two approaches and they're fairly marginal difference and we're going for one, but we could equally go for the other. In fact, the current test is very uninterventionist. The reverse burden approach would be very interventionist, and there's a long way up between them. So I think there is an argument for a halfway house of some sort, and I think thought should be given to what that halfway house might look like. One option would be to require the agency to demonstrate a reasonable prospect of harm, so maybe 25-30% likelihood of harm, and for the burden then to shift to the parties to show that efficiencies exceed that expected harm. That wasn't the approach proposed by the Furman review, but I do think it has some merit. Or there is the balance of harms option that was proposed by the Furman report. The aim of that was to enable intervention against mergers with a relatively low likelihood but of very substantial harm. So to take that quantum of harm into account in the merger review. That's very in line with economics. It's much more similar. It's essentially the same as calculating an overall expected value of the merger, which makes total economic sense. It has been highlighted that it has practical issues. I think it is workable. I think it's worthy of further consideration, but I don't really have time in this short session to go into that. I would highlight that some jurisdictions feel that they can more or less already do this themselves. So great, let's see more of that without changing the law. And the final question I was asked to comment on was the US FTC has pursued some recent mergers as monopolization cases alongside standard merger review. Could this approach be used more broadly? So I only heard about this quite recently. I think and it was used in the US case against Illumina PacBio, I understand. Now, I'm no expert in US law, but it did remind me of an old debate in the EU. As you'll be aware, the EU merger test was changed from the test that prohibited the creation or enhancement of a dominant position to the current SIEC test. And the reason was that we felt quite rightly there was a gap in that there was impossible to intervene under the dominance test against 4-3s and 3-2s, which clearly limited competition, but there was no dominance, and that's an old discussion. I think what's interesting, if you think about something like Illumina PacBio, is actually that's a merger where the old test might have been incredibly appropriate. So that, that looks like an enhancement of a dominant position type of a case. And I essentially think that's what the US are trying to do by applying the monopolization rules. So in the Furman report, we did spot this issue, and to address it, we suggested changing the UK merger assessment guidance to emphasise that any merger which created or enhanced a dominant position should and would be seen as a substantial lessening of competition under the merger test. And I think that taking this sort of approach, which I hope the CMA will take forward in its guidelines, should be sufficient to avoid the US approach of utilising two different strands of law at once. But let's see. So I think I've answered the questions that were put to me. I am very much looking forward to the discussion that will come. Thank you very much.